On Tuesday, April 9th, Jennifer and James Crumbley, the parents of the Oxford school shooting, were sentenced to 10 to 15 years in prison. The sentencing itself took a little over 2 hours. It was filled with emotional comments and victim impact statements. It was also the time for Jennifer and James to provide statements to the victims as well as to the judge. Hello, I'm Deborah Lelli, and welcome to my channel. If you're new here, don't forget to subscribe and activate the notification bell to stay up to date on all upcoming videos. Let's get started. On April 9th, the sentencing began by going over the pre-sentence interview. The pre-sentence interview is something the adult probation generally does when they make their recommendation. So generally what happens is that the Adult Probation Department will interview the defendants. They will make their recommendation to the court. A defense attorney will also have an opportunity to submit a sentencing memorandum, as well as the prosecution team will submit their recommendation to the judge. The judge will determine based on both recommendations what the sentencing will be. Of course, they're also going to listen to victim impact statements as well as what the defendants have to say. In this case, there's a couple of things that both attorneys want to remove from the pre-sentence interview. Both of the reports list the son as a co-defendant, which technically he was not a co-defendant to this case. So that's something that both of the defendants do want to remove. Another thing that they do point out, at least for Ms. Crumbley, is that she is a drug abuser. However, the judge does agree with the defense on that she was not. So that does get removed, at least for Ms. Crumbley, not for Mr. Crumbley, because it is noted that he does smoke marijuana on a regular basis. So that does get left for him. There is comments made about both of them consuming alcohol on a regular basis. There is comments made about substance abuse regarding alcohol. That was left there, even though both parties did object. Let's take a listen to that clip.
Does it sound like drug abuse?
Sure, Judge.
I mean, for some people, I guess. So I'm going to strike drug abuse as it relates to Mrs. Crumbley, but keep substance abuse and alcohol abuse as to both in the pre-sentence investigation. All right.
Another issue that's brought up is a no contact order between the victims. And this is kind of interesting just because technically all of them could potentially be going to prison. And so because mother would be going to a female prison, father and potentially the son could be going to the same prison, they wanted to ensure that there would be no contact. Generally, what happens when in situations like this, when they are arising out of the same incident, what would happen is that the prisons would treat them as enemies, and that's kind of what would happen in this situation. So the issue can potentially become moot, but what is decided in this case is that they are going to table the discussion and they will brief the issue. While there is some discussion about how they are going to proceed on the issue of whether there can be contact because it is a family, the prosecution team just wants these defendants to be treated the same as all defendants and not necessarily treat them different because they are a family. Now, one last thing that is worth noting before the victim's family starts speaking is the sentencing chart and the guidelines that the judge has to follow and where the particular defendants are scored. So the defense makes an argument that the defendants should be scored lower than where the probation department has scored them. And the way that the defense attorney tries to make the argument is that the defendant's behavior was just based out of one incident. Now, they were charged 4 times because of the 4 victims in the case. However, their conduct, their behavior towards their son was just 1 time. And that's an argument that they don't actually win because the prosecution comes back and states, even though the behavior was 1 time, the jury found them guilty of each individual count, and that behavior led to the killing of each individual victim. And because of that, the judge does not agree with them, and their sentencing charge, their sentencing guideline, and the score that they are scored, the judge does agree with the prosecution side and the probation department, and does score them higher on their sentencing guidelines. Once that portion of the sentencing is complete, then it's the opportunity of anyone who wants to speak on behalf of victims, and they are able to read their statements, or they are just able to speak. I'm not going to talk on that. It's very difficult to watch, so you are free to watch it at your own leisure. I do want to point out that the very last father who does speak, he does not acknowledge the Crumbleys. He does not acknowledge them because he states that he has already given them enough time, but he does ask for the truth to come out. He does make points about holding the school accountable, holding the police department accountable. He's upset because the sex of his child was given to him incorrectly. There was just some discrepancies that were made, and so he's asking for accountability, and he's just upset. He's very upset when he provides his statement. But if you want to watch it, I will definitely put the link below so you can go ahead and view that. After that, the statements are made by the defendants, and Ms. Crumbley speaks first. Ms. Crumbley reads a statement where she basically talks about her initial statement that she made during her testimony at her trial. One of the biggest controversies of her was that one of the questions she was asked, and I will place a link to my YouTube video where I covered her trial, was that she was asked if she could do anything different, would she? And she stated no. And that's something that a lot of the parents held on to. And she tried to fix that by trying to explain what she meant by that. I don't necessarily think she did a good job explaining it. It looks like she was trying to show remorse, which is something that is a mitigating factor. However, a lot of the parents spoke, a lot of the family members talked about how neither of them, Jennifer or James, showed any remorse.
When I was on the stand, I was asked if I would have done anything different. I was horrified to learn my answer I would not have was completely misunderstood. That answer is true because my son did seem so normal. I didn't have a reason to do anything different. This was not something I foresaw. That was the intention of my answer and how I interpreted the question. With hindsight and the information I have now, my answer would be drastically different. If I even thought my son would be capable of crimes like these, things would have absolutely been different. Even worse, when I learned during the police investigation that he had been planning a school shooting before November 30th. He was not the son I woke up. He was not the son I knew when I woke up on November 30th. The Ethan I knew was a good, quiet kid. He loved his pets, family vacations. My husband and I used to say we had the perfect kid. I truly believed that, and that's who I saw and thought I knew. As the details started emerging during discovery, I was horrified to learn concerning behaviors my son was reported doing at school.
I'm going to pause it there because she continues talking about the information that she learned, but again, feel free to watch the rest of her statement. However, something that I noted that she doesn't do is take responsibility for her inactions. So a lot of what she apologizes for are the actions of her son. And as a defense attorney, something that I always tell my clients, a mitigating factor is to accept responsibility. So when you take a plea agreement or you're found guilty at trial, clearly a mitigating factor is remorse. And something that she did not do is show remorse. And that's something that the prosecution, when it is their turn to talk, is talk about how they do not show remorse, her or James. Crumbley's attorney talks about the remorse that he feels, the remorse that he talks about in his statement. And she also goes in and talks about the weapon, the evidence presented at trial. She talks about that there is no evidence that was presented at trial that he actually knew what his son was up to, that there was no evidence presented that there was any way that he could have known what was going to happen. Here you can take a listen to some of her remarks. She also talks about how the weapon was stored legally at the time.
I want to note for the court that, especially in statements that have been made about James, that he lacks remorse, that he doesn't feel bad, that he's trying to put off responsibility on everyone but himself, that he's allegedly made threats toward the elected prosecutor. Your Honor, in some of the same calls that the prosecution has tried to use and has quoted in their own sentencing memorandum and attached as exhibits to their memorandum, as I noted in my sentencing memorandum, Your Honor, James also said in those very same calls that he wished that he had known what his son was capable of. That if he had known, if he had been made aware of these things, if he had known that his son had obtained access to a firearm, that maybe he could have saved the 4 children's lives. That maybe he could have saved a lot more than that. Your Honor, there has never been a time that James Crumbley has not acknowledged what happened in this case. He has felt horrific grief for not only the families, but for the people who have been affected. He's grieved for himself, for his own child. And while that may not be something that is a popular statement to make, he's grieved for the child that he believed he had. Not the child who pled guilty, but the child that he believed he had on the morning of November 30th when he dropped his son off at school. James could not have predicted what his son was going to do that day. He couldn't have predicted because he didn't know that it was going to happen. As James said, Your Honor, you sat through the trial, Judge. You heard the evidence that was presented. You also know that there was no indication given in the evidence presented that James had knowledge of what his son was planning. That James didn't know that his son had been accessing that firearm unsupervised, or that he had access to the firearm unsupervised. Judge, you heard that that firearm was stored legally at the laws at the time in November of 2021. That there may be differing opinions on whether or not that firearm was stored responsibly, Your Honor, but it was stored legally. It was stored unloaded.
Both of them talk about what their son did, and apologize for the actions of their son, which clearly their son took a plea, accepted responsibility, has been sentenced, and is in prison. However, they are on trial for their actions, and neither of them take responsibility for their actions. And that's something that the families wanted to hear, and that's something that the prosecution team does point out.
This insinuation that if only I had known he was sleeping in class and teachers might have been concerned, then none of this would have happened, is at the core of why we saw 6 people standing here and saying there's no remorse or accountability. And I want to be clear, remorse does not sound like I feel really bad. I'm sure they do. I don't dispute they feel bad. I don't dispute they have grief. That's not the kind of remorse and accountability these victims are looking for. What that looks like is we messed up. We should have done this and we didn't, and we are very sorry. And that has not happened, which is what we're talking about here and what you heard the victims say.
The judge issues her ruling. She makes comments to each defendant about their role. Let's take a listen.
Opportunity knocked over and over again, louder and louder, and was ignored. No one answered. And these 2 people should have and sure didn't. Mr. Crumbley, it's clear to this court that because of you, there was unfettered access to a gun or guns, as well as ammunition in your home. You characterized yourself as a martyr and threatened the well-being of the prosecutor. Mrs. Crumbley, you glorified the use and possession of these weapons. Your attitude toward your son and his behaviors was dispassionate and apathetic. Your response to school staff after a 12-minute meeting was, "Are we done here?" During your trial, you announced that you wouldn't do anything different. I understand that might have been misinterpreted. but it did cut the victims deep. Because of both of your actions and inaction, among many, many other things, the world is missing out on a top college university will need ability for rehabilitation, the need to protect society, the penalty appropriate to the conduct and goal of deterring others from similar conduct. I have reviewed the pre-sentence investigation reports. I am, of course, sadly familiar with the facts and circumstances of these cases, as well as those surrounding each defendant. The advisory sentencing guidelines in this matter do not capture the catastrophic impact of the acts or inaction in these matters. The guidelines do not take into account the complete lack of insight both defendants have for their behavior to this very day. The guidelines do not account for the severity of the circumstances in this matter. The guidelines ignore the survivors, including shooting victims Phoebe Arthur, Elijah Mueller, Riley Franz, Kylie Osage, John Asciutto, Molly Darnell, and Aiden Watson. They were deeply wounded, both physically and emotionally. In addition to the 7 wounded, each of the defendants' gross negligence has caused unimaginable suffering to hundreds of others as a result of what happened that day. Each act or inaction created a ripple effect. Therefore, an out-of-guidelines sentence is appropriate and proportional. The court uses the useful tool of the legislative guidelines, which embody the principles of proportionality, while also taking into account the nature of the offense and the background of each defendant. I believe that the following sentences would be in the best interest of justice and are reasonable and proportionate to the seriousness of the matter and the circumstances surrounding each defendant. With regard to Jennifer Crumbley, it is the sentence of this court, Ms. Crumbley, that you serve 10 to 15 years with the Michigan Department of Corrections. You will have credit for 858 days. As to defendant James Crumbley, it is the sentence of this court that you serve 10 to 15 years with the Michigan Department of Corrections, that you receive credit for 858 days.
Well, there you have it. That was the sentencing of Jennifer and James Crumbley, the parents of the Oxford shooting. Let me know your thoughts. Let me know if you think that was a fair and just sentence for both of these parents. If you have any questions, don't forget to drop them in the comments below. As always, thank you for watching. Don't forget to share the video, and I will see you next time.